And it looks like, oh, we've got to get our YouTube going here. So just a moment. So I'm just going to check my notes here and make sure the YouTube is going. Okay. I have confirmation YouTube is going as well as Zoom. So good morning. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. Today is February 2nd, 2022. And this is a status conference on the City of Solvang's petitions to change water right permit 15878. With me assisting on Zoom from my staff are Amy Blanc, Skylar Anderson, Nicole Mullen, and Kyle Woldridge. And as always, I greatly appreciate their assistance. I couldn't possibly run these proceedings without them, and they do very well. I have not ordered a court reporter for this status conference. So we are recording this conference by Zoom teleconference and also YouTube Live, and the Zoom video plus audio recording will become part of the official record in this matter. It looks like we have, I'm not going to repeat the process for this status conference because we've had several of them before in this matter. And I think most all of you are familiar with those, but I do want to make sure we have appearances on the record since it's been a while, just to make sure we have a record of who's representing whom. So I'll start, Ms. O'Sullivan or Mr. Kim, would you like to enter an appearance for both of you for City of Solvang?
Yes, good morning, Mr. Lilly. This is Chelsea O'Sullivan appearing on behalf of the City of Solvang, and my colleague Tilden Kim is also appearing on behalf of the city.
All right, and good morning to both of you. Let's see here. Who do we have for today for Alisal Guest Ranch?
Good morning, Mr. Lilly. Jessica Diaz appearing for Alisal Guest Ranch.
Okay, and that's fine. Good morning, Ms. Diaz. I had Stephanie Hastings on my notes, so I will cross her name out and add yours. And then for Improvement District number 1.
Yes, good morning. This is Elizabeth Esposito for ID number 1.
Okay. Good morning, Ms. Esposito. And for NOAA Fisheries?
Good morning, Mr. Lilly. This is Darren Brumback with NOAA Fisheries. And our council, unfortunately, is not able to attend today. That's
all
Ms.
right.
P.
Well, I'm sure you will be able to report to her what happens. Give Ms. Beal our regards. And if there are any questions, you certainly can answer them. And if we need more time, we'll set another status conference if we have to, which we may be doing anyway.
Okay.
All right. So for Cal Trout.
Good morning, Mr. Lilly. Maggie Hall on behalf of California Trout.
All right. Good morning, Ms. Hall. San Ynez River Water Conservation District.
Good morning, Mr. Lilly. Steve Torgiani for San Ynez River Water Conservation District.
All right. Good morning, Mr. Torgiani. And for California Department of Fish and Wildlife.
Good morning, Mr. Lilly. Lena Germanaro for Cal Fish and Wildlife. And I think Nancy Murray is also on the line.
I see a tile for Nancy Murray, but I don't see her face. Ms. Murray, are you hooked up? There you are. Okay, you're on mute, but you can go.
Yes.
Yeah.
Sorry, the YouTube. I was having trouble with the YouTube, so I joined Zoom.
Okay. Well, maybe I should just double check. Mr. Anderson, is the YouTube now running?
The YouTube's working.
Okay. Yeah, it takes a while to get all the things connected, so that apparently is why there was a delay. But apparently it's working now. So, is there anybody who I have missed who is going to participate in today's conference?
Mr. Lilly, if I could take the time just to introduce Jose Acosta. He's the City of Solvang's new Utilities Director. So he's watching and listening today, but wanted to introduce him.
Okay. Well, good morning, Mr. Acosta, and welcome to the process.
Good morning. Thank you. Appreciate it.
All right. So with that, does anyone have any questions about our process today before I get started? As I say, I think you're all pretty familiar with it. All right, so let me just tell you where I am and we can figure out where we're headed. First of all, I appreciate all of your participation today. I think it is good just to all get in the virtual room together and talk about where we are and where we're headed and proposed schedule. So my office I issued a status conference order and notice of new status conference and planned hearing schedule on September 2nd of last year. And then in response to a request for extension of time from the city of Solvang, I issued an order on request for extension of time on November 12th of last year. And with that, the schedule and then the amended schedule required parties, primarily the city of Solvang, to make various filings with the Administrative Hearings Office. And most important, the amended schedule had a February 1st, that would be yesterday, deadline for Solvang to file copies of the documents required for its CEQA compliance for the city's petition to change water right permit 15878. And Ms. O'Sullivan sent a letter to the Administrative Hearings Office with copies to everyone on the service list on January 18. And that letter transmitted a copy of the city's resolution 22-1154, in which the city adopted a CEQA addendum to the city's 2011 EIR. And then on January 21st, after we got the logistics figured out, the city uploaded copies of the addendum and the technical appendices. I think they're appendices A through E to the AHO FTP folder. And my staff moved those files over to the hearing documents folder where all of you could access them. And then just this morning, a few minutes ago, I thought it was a little confusing having those in the hearing documents folder. So I created a new folder for the City of Solvang matter, a new subfolder within that matter, titled 2022 CEQA documents, and moved all the CEQA the files related to the CEQA addendum into that new folder. Just so they're a little easier to find. Now, I apologize, and this is certainly my, I would say, oversight or just inability to get to it, but due to my office's workload and other matters, I did not or have not yet notified the other parties that we transferred these files and have posted them to our FTP folder. Of course, you all did receive copies of Ms. O'Sullivan's letter, so you knew that the city transmitted them, but we just didn't get to it till now, and I apologize for that. So I'm just going to ask, maybe just, well, I don't know first of all, I'll just ask, did anybody besides City of Solvang, has anybody seen and at least briefly reviewed or downloaded those new CEQA documents? I'm seeing a lot of blank faces, so I'm going to assume that means nobody has, and that's understandable because I did not notify you that they were there.
Mr. Lilly?
So, yeah, go ahead, Mr. Broomback, please.
Yes. Noah Fisheries, I've downloaded the documents. Thank you.
Okay. I don't know whether that means you get a gold star or what, but anyway, you're on it, and thank you. So besides Noah Fisheries, has anybody else downloaded those CEQA documents yet? Or reviewed them? Yeah, Ms. Hall, go ahead.
Mr. Lilly, we reviewed the documents in the context of the city council hearing and the agenda they posted with the link to the documentation. So we reviewed it in that context, but have not re-downloaded it.
Okay. Well, I assume they're, Ms. O'Sullivan, I assume they're the same documents, but.
Yes, Mr. Lilly, they're the same.
And don't worry, Ms. Hall, I'm not going to call on you and ask you technical questions about them. Not today. Down the road, we may be asking your witnesses about them, but not today. And Ms. Esposito, your hand was up. Please go ahead.
Yes, we've downloaded the documents as well.
Okay, well, that's good. So thank you. Notwithstanding my oversight, you're all on top of this, and I appreciate that. So this is a major step forward. Of course, I understand parties may have disagreements with the technical documents, and I have not reviewed them, and certainly don't have the capability to do a detailed technical review without assistance from my staff and all of your technical witnesses. But nevertheless, this is a major step forward. We've been waiting for this for a while, and obviously the city had to put, and its consultants had to put a lot of effort into completing those documents. So I'm going to ask you all for your input on a proposals for a schedule for the pre-hearing and hearing process. And if we need to have another status conference before we firm up the pre-hearing and hearing schedule, we will, but I'd like to see where we get to today. Again, this is fairly informal today. So before I do that, though, I want to explain to you how things work with the Administrative Hearings Office. Some of you have participated in hearings either before the Administrative Hearings Office, or actually, I'm not sure any of you have participated. Maybe some of you have, I'm not sure. Or prior state water board hearings where they followed generally the same process, and those were hearings before the legislature created the Administrative Hearings Office. And the reason I want to go into this in a little detail is it's somewhat different from court proceedings, which you as attorneys are probably all much more familiar with. And I'll just say there's sort of an ongoing problem with people not appreciating the way we do things. And I want to try to avoid that. So here's what we do. And the reason we do this is and this is the State Water Board, even before there was an Administrative Hearings Office, has concluded it's a far more efficient and expeditious process than a normal court proceeding. My rough estimate, and I did practice before the Water Board for about 30 years as an attorney representing parties and participated in numerous water right hearings. So I have some basis for stating this, and that is, I think just kind of in rough terms, the Water Board hearing process can cover in one day what takes a normal court civil trial about a week to cover. So it really is a lot more efficient. And it also obviates the need for all or almost all discovery, which is, for those of you who do civil trial work, it's a tremendous amount of time and expense. I'm pretty sure I never took a deposition in the 30 years of water right hearings that I did as an attorney, and I never felt like I was really at a disadvantage for not having done that. And I'll tell you why with the process. So here's the process. We issue a notice of hearing, we specify the hearing issues, and we did issue a notice of hearing in this matter back sometime in 2020. I forget, around the spring to summer of 2020, and it's in the record and you can look at it. I don't know that the hearing issues have changed a lot. Obviously, there'll be some updating, but the process is generally the same. We've updated our hearing notice template a little bit, but the hearing notice specifies the hearing issues. We specify a deadline for all parties to submit their written proposed testimony. They upload it to our FTP folder, and then we post it so everyone can download it. So people don't have to mail paper copies. We do it all electronically. And that's usually roughly 30 days before the hearing starts. And of course, everyone can review that written proposed testimony, and people also follow their exhibits, and people can review those. And usually the written proposed testimony refers to the exhibits. We have authenticating exhibits. People sometimes have declarations for the written proposed testimony. That's not really necessary because during the hearing, each witness takes the oath and affirms that the written proposed testimony is, in fact, his or her testimony for the hearing. So that takes care of the oath requirement. It's not, if you do a declaration, it's not a problem, but you don't need to. And then I allow each party to ask its witnesses to summarize their written proposed testimony. And this is where people get into trouble. A summary really does mean a summary. That means you say, as discussed in paragraphs 1 through 8 of my testimony, I have this education and this experience. As described in paragraphs 9 through 20 of my testimony, here's the work I did on this project. And as described in paragraphs 23 through, I'm just throwing out numbers, obviously, through 35 of my testimony, here are the conclusions I've reached. And our hearing notice encourages people to prepare slides and submit those as a separate exhibit, and then use the slides to summarize their testimony. And the reason I'm telling you all of this is, when we lay it out as clearly as we can possibly write this, but inevitably somebody shows up at the hearing, they've submitted their written proposed testimony, and then they start reading from a script that has new material, does not track their written proposed testimony. And then another party objects and says that's not in their written proposed testimony. They shouldn't be allowed to do that. And then it just ends up being a big mess. I feel bad about not letting witnesses testify. But on the other hand, in fairness to the other parties, especially since, as I said earlier, a lot of times they do not do discovery, their only notice of what the witness is going to testify to is the witness's written proposed testimony. And if the witness deviates from that, expands on, usually the problem is they expand on that, it's not fair to the other parties. And also, if the summaries, I usually allow 30 or 45 minutes. If the summaries drone on for that, I mean, I usually have time to hear them, but that also is not fair to the other parties, because if somebody else has prepared having its witnesses do concise summaries meeting the time limit, it's really not fair then for another party to drone on for an hour and a half or 2 hours with their summary. So if it sounds like I'm lecturing, I guess I am. But I wanted to let you all know this so that you can follow the rules. It's really more in fairness to each other than it is to me. I mean, I want to have an efficient process and all that, so I do like that. But it really just is not fair to another party if one party deviates from those rules. So I'm going to just pause for a minute, and feel free to ask any question. There are no dumb questions here, but does anybody have any questions about that process? We certainly will spell it all out in our hearing notice, which is about 20 pages long, and please do read it all because it's important. But having said that, does anybody have any questions about the process we use here? Okay, I'll say then.
I did have one question.
Mr. Turcotte, please.
Sorry, I was a little slow to turn off the mute.
No, that's fine.
In terms of if somebody doesn't submit written testimony and exhibits, my understanding is that they could still reserve the right to submit rebuttal testimony and exhibits and conduct cross-examination. Is that appropriate?
Good question. You anticipated right where I was headed, so thank you. So yes, parties may submit notice, and we're going to have a new round of notices of intent to appear because it's been so long since the last time. And there are various boxes to check in the notice of intent to appear form. And one of them is I will be submitting written proposed testimony and exhibits. And another is I want to participate, but just for cross-examination. And I think it may say rebuttal. And parties certainly may do that. However, if somebody doesn't submit written proposed testimony as part of their case in chief, they can't then show up at the hearing and have to say, I've got this new witness here. I want to submit this testimony. It's because, again, that's just would not be fair to the other parties. So again, the reason I'm spending so much time on this now is it's going to have a bearing on the pre-hearing schedule, because what I hate to see people do is prepare their written proposed testimony, and then it's like, oh, great, I've got 30 days till the hearing, and they basically rewrite the whole thing, and then they read something at the hearing that's different. And you may say, why would anybody do that? Well, They do. And I just don't want people to do that for the reasons I just said. So getting to Mr. Torziani's question, people parties may file notices of intent to appear and say, I will participate in the hearing, but solely for the purpose of cross-examining other witnesses. And of course, then making, if they want to, filing closing briefs. So that certainly is allowed. Rebuttal was the other question Mr. Torziani asked, and that's very important. My office has taken what was previously an informal process with the State Water Board water right hearings and made it more formal. What we do is our hearing schedule, and I think this was in the proposed hearing schedule, we'll have a separate deadline after the first hearing for people to submit written proposed rebuttal testimony and rebuttal exhibits, and then we'll have another round of hearings for that. And I do want to explain carefully what rebuttal is and what it is not, because we also sometimes have problems with this. What rebuttal is not is oh yeah, I forgot. This is a really important exhibit. I forgot to submit that in the first round. Now I'm going to submit it in the second round. Kind of to put it colloquially, a rebuttal really is limited to responding to some evidence. So-and-so's evidence says that the flow in 1997 in April was this, and that had this effect on the fish. And my witness disagrees. He or she thinks the flow was this, and it had this effects in that same month. I mean, this is maybe a little more specific, but what I do require is in the written proposed rebuttal testimony, each part or each paragraph or each part specify this is rebuttal to, I'm party B, this is rebuttal to party A's testimony in this, by this witness or in this exhibit. And I'm responding to that. And that we allow because that's almost for a due process matter. I think it's in the government code. I think it's 11513 subdivision B. We have to allow rebuttal. And of course, we want to be fair. So we will allow rebuttal, but it's got to be very clear what it is rebutting when the rebuttal testimony is given. So again, we'll have another whole round. We usually that will cover it. I guess in theory, we can have a round of SIR rebuttal if we need to, but at some point we should be really focusing in we should have it all covered. The bottom line is this shouldn't be a gotcha game where somebody can put in evidence and not let somebody respond to that. But on the other hand, everybody needs to be forthcoming with their evidence. But I want to have everything that's relevant on the record, in the record, so that I can use that going forward to make an informed written proposed order that I then transmit to the water board. And while we're on this, just one other little point, not a big point, but I might as well make it so that you can follow our rules. Written proposed testimony. You have written proposed testimony of witnesses A, B, and C. Please just label those as exhibits. I know for those of you who do trial work, it's a little counterintuitive to have testimony be labeled an exhibit, but it's just a record keeping thing for us. So if City of Solvang or Solvang 1 is the written proposed testimony of witness A, then I can just refer to that. Let's pull up on our screen exhibit Solvang 1, and we'll go to page 5. It just makes it easier. So please just label your witnesses written proposed exhibits, one for each witness. And then I strongly encourage summary slides. Same thing, just label those as another exhibit. So the summary slides could be Solvang 8 and put up Solvang 8, slide 5. It just, again, we have a very clear record, and it helps my staff locate the files, do our screen sharing, get them on the screen. And I do like if somebody's asking a witness, particularly on cross-examination, about a particular exhibit, if we have it on the screen for screen sharing, everybody can see it. We have all the people on the view, and it just makes a really good, clear record. And the questioning is just a lot clearer, obviously, if the exhibit is up there. So yes, thank you, Mr. Torgiani. I don't want parties to hold back relevant testimony for rebuttal. And of course, if you do that, you run the risk that the parties who you think you're going to rebut doesn't put it on in their case in chief, and then you may not put it on in rebuttal. So, and it's, if you think, well, I'm going to get them, I'm going to save it till rebuttal, and then they won't be able to respond. I mean, I'm not going to let that happen. Obviously, if there's something that comes in on rebuttal that somehow opens up a door for something new, we'll allow SIR rebuttal. So you're not going to get any tactical advantages. I mean, this isn't like I think a football, because we just had the playoffs. This isn't like we try to get down to the 5-yard line and then time runs out and we say, okay, done. We're trying to get to the truth here, not some kind of a sporting event. Probably a bad analogy. But anyway, I'm going to pause again. Any other questions about the hearing, the pre-hearing? Or one other thing. After we finally get done with all the rounds of testimony, then I will give the parties time to prepare and file closing briefs. And the hearing notice, I think, has some provision for either oral closing argument or written closing briefs. But in a case of this complexity, and this case does have some pretty significant technical complexity, I think it's better for all of you, and I know it's better for me, if we have written closing briefs, because then you have time to prepare something, to have good citations to all the exhibits and testimony in the record. And then when I'm going through and working with my staff to prepare our proposed order, we have written materials we can look at, and believe me, we read them pretty carefully. So we will definitely do closing briefs and not closing arguments. But I do allow short opening statements, just the way they are in court, although much shorter, just to basically summarize what the parties, witnesses, what the anticipation will be that they will testify to. And you ought to have a pretty good idea by then, because they've already filed their written proposed testimony. And then closing briefs. And then it comes to me, to my office. We prepare, it's deemed submitted under Water Code. I think it's 1114 at that point. We, by statute, have 90 days. We can take longer if we have to, if the matter is technically complex, and this one may be. But we try to get out what I call a draft proposed order within that 90 days. And at that point, we vacate the prior submission and allow parties to comment on the draft proposed order. And this, for those of you who do trial work, this is pretty similar to a tentative decision that most trial court judges do in superior court proceedings, civil proceedings. And then I allow parties usually about 30 days to file comments on the draft proposed order. Then the matter is deemed resubmitted, and our second 90-day clock starts running, and we prepare a final proposed order, which we then transmit to the board. And then the board has 90 days to act on that. And Water Code 1114 specifies 5 or 6 different types of actions that the board may take. Of course, the first one is adopt the proposed order without any changes. And our goal is to prepare a proposed order that the board will do that with. But they're the final decision makers, and sometimes they have input and go in different directions. One of the main reasons I do the draft proposed order process, and my colleagues do, is, frankly, I usually get a lot of good comments. There's things we miss. We may not have had everything right. We've made mistakes. And I'd rather clean all that up before I send it to the board. It makes the board process go much more efficiently. I mean, there may still be policy or significant legal issues that the parties disagree on, but I try to make it so we take care of the sort of minor error stuff and get that cleaned up so the board can really focus on the major issues. And I think it's a service to them to do that. So I'm going to pause again and ask if there are any questions about that. I have rambled on a bit, and I apologize for that. Because then I'm next going to ask for parties ideas about what a reasonable schedule is for these various steps. But does anybody have any questions about the pre-hearing and hearing process that we use here? Okay. Either it's clear or you're all still waking up with your first cup of coffee. But anyway, I hope it's clear. So we now have the technical information from the city of Solvang, the addendum and I think it was 5 technical appendices, which I have briefly reviewed, certainly have not looked at them in detail. They have a lot of technical information. I assume, Ms. O'Sullivan, that the city's case in chief will be primarily based on the addendum and the technical documents, although certainly there may be other exhibits that you submit, and you will have witnesses with their written proposed testimony to talk about these exhibits. Is that correct?
Yes, the addendum is the secret documentation for the project, and we'll be using that for the basis for our testimony and our technical information.
Okay, so all the other parties have at least, I'll say, a fairly good idea of what the city's case is going to be. And I'm not holding you to that, Ms. Sullivan. Obviously, O'Sullivan, when we have the hearing notice, the city can prepare whatever documents it wants, but I'm sure the secret documents will be a major part of the city's case. So, and the other parties previously had submitted comments. We've been through a few rounds of, I'll call it pre-hearing technical discussions. A lot of the comments in the prior rounds were that basically the city had not provided adequate documentation to support its petition. The city now has provided documentation. I'm sure some of you may dispute whether it's adequate or whether you agree with it. But having that, I'll just say, first of all, if you can, and I'm not going to hold you to this, but this is just for planning purposes. Are there any parties that plan, assuming the city puts on a case in the rough terms that Ms. O'Sullivan has described, are there other parties who plan to put on cases, I'll say, in opposition to the city's case? And do you want to just raise your hand if you think you might be doing that? Or if you know? Okay, Ms. Hall for sure, and Mr. Germanario for sure, and Mr. Brumback. We'll give you a maybe until your attorney is here, but I suspect NOAA Fisheries may want to. So I'm not surprised. I would expect that Cal Fish and Wildlife, NOAA Fisheries, and Cal Trout would want to put on, I'll call it opposition cases. I don't, we'll see exactly how they play out. Are there any other parties who think they will be putting on substantial cases in opposition to the city's petition? I know there have been some settlement agreements, so I'm just trying to get kind of a handle on the numbers of parties. So, okay, I don't see any other hands, and that's sort of what I thought the lay of the land was. Incidentally, if you can settle, please keep talking. If the city and Cal Trout, Cal Fish and Wildlife, NOAA Fisheries talk and settle, that's certainly fine. I don't want to be involved in any of those discussions. But if you can enter into a signed settlement agreement that resolves the issues raised by the pending protests, and we don't need a hearing, that's fine with me. Just let me know. But I'm not going to delay the hearing schedule because of settlement discussions ongoing. You're going to have to double track those if you want to have a settlement. I just, in my experience, the best way to get a settlement is to have a schedule about what happens if the parties don't settle. So, Mr. O'Sullivan, is your hand up, or are you just?
Yes, I thought this might be a good point just to mention that the city did receive a joint settlement proposal from Cal Trout, CDFW, and National Marine Fisheries Services yesterday. It is quite technical, so we are working expeditiously to review it and consider the terms. But we will need input from relevant city staff and our consultants to really evaluate and come up with a counter proposal. And then we'll likely need city council input on any counter proposal and certainly any final settlement if we get that far. So I hear your comments that you're not interested in delaying the schedule because of negotiations, but did want to make you aware that we are making progress, but the terms that we're discussing are technical and will take some time to evaluate.
Okay. And yeah, that's okay. I haven't set a hearing schedule yet, so maybe I won't delay it once I set it, but it may be worth factoring this in when we're discussing what an appropriate schedule is. And in fairness, I will just say, in fairness to the other three parties, first of all, I'll say it's great that all three of you are coordinating. I mean, what would really drive me crazy is if we got three different settlement agreements with different proposed permit terms, some of which might have been inconsistent with one another. So the fact that the three, I'll just call it the three fishery parties, are coordinating is great. And the fact that you're talking with the city is great. And I certainly understand why you didn't do that before, that you needed the technical documents to be able to basically have a technical discussion. And I certainly understand that this is technically a very complex matter. So that's good news. Please keep it up. As I say, my office, I don't think there's any reason for us to get involved. We do have a statutory authority to do mediation, which we could consider here if the parties thought it would be helpful. That I'll just say that the reason I'm hesitant about that is I only have myself and two other attorneys as hearing officers. And I do feel very strongly that if one of us participates as a mediator, then he or she should be totally excluded from the hearing process. I know judges do it sometimes, and I never thought it was fair. You lay out all your weaknesses and strengths and where you're willing to give and where you're not in front of the settlement judge, and then it doesn't settle. And then that same judge presides over the trial. I've always thought that was really pretty unfair to the parties. The judge says, I won't remember any of that if we go to trial, but it was always a little hard to believe. So anyway, long way of saying I do have two other attorneys in my office who potentially could be mediators in this, but I don't really want to do that unless you all advise me it would really be necessary. And frankly, you're all experienced, qualified attorneys, and are very, from what I can tell, are all very, not Mr. Broombeck, you're experienced and professional, just not an attorney. But the rest of you, and I'm sure Ms. Buell fits in this category too, you're all experienced, qualified attorneys, and you know how to work professionally and work out a deal if there's a deal to be made. So please do try to do that if you can. I'd love to have a hearing in this matter. I think they're fascinating technical issues. But obviously, if you can work something out that's acceptable to all the parties, that's going to be in your benefit. And frankly, you may be able to include provisions that go beyond the state water board's authority. Sometimes there can be mitigation measures and so forth that really the board does not have authority to do. So sometimes a settlement can kind of have a broader universe that can be useful. So anyway, thank you, Ms. O'Sullivan, for letting me know about that. And thank you all. Please persevere. And I guess the only thing at this point I'll do to try to facilitate a settlement is set a hearing process and kind of put some, I don't know what the right word is, incentives to settle, because otherwise you'll need to have a hearing. And it may mean you have to dual track your settlement discussions and your hearing preparations. So with all of that, Mr. Kim now has his hand up. Good morning, Mr. Kim. Please go ahead.
Good morning, Mr. Lilly. In the event that the parties who are currently in settlement discussions all mutually believe that a mediation session may be productive towards exploration of settlement, what is the process in which we would do that? Would we just collectively notify you that we would like the appointment of a mediator? And so that's question number one. And question number two is, given the timing issues that you've raised, how quickly can that mediation process be scheduled? Okay.
Well, good questions that I won't be able to give good answers to, but I'll try. We've never done, our office was just opened 2 years ago. And frankly, the first year was a lot of logistics. I had to hire people and set up all this infrastructure, administrative structure we do. So we haven't been going very long. We're going pretty much full speed ahead now with hearings. But we have not ever done a mediation. So that's why I'm a little hesitant to give you a clear answer. But here's what I suggest you do. First of all, meet among all the parties. And if you think, if you think I'll just say that there's some realm of possibility to settle and that you're all interested in really engaging, then discuss having a mediator. And there are a couple of ways to do that. I mean, there are mediators out there in the lawyer world, maybe even some who aren't lawyers. And you can, of course, hire a mediator. You can figure out how you want to do that and have a mediator, conduct sessions. I think it is important to go pretty quickly on that. There are some, that I'm sure there are some services that do civil mediation, and you can get one of them. Usually it's a retired judge, and a lot of them are quite good. They're expensive, but they're good. So that's one possibility. I don't have to be involved in. I do ask that you try to get a prompt schedule. Usually, if it's going to settle, you can do it in a couple of mediation meetings. Either you will or it won't, and you'll know. So I don't know that needs to be a long delay. If you don't want to do that and you want to prevail on the state water board, let me know, and I will see what I can do, either with somebody in my office or potentially some attorney in the Office of Chief Counsel, who then would be, in some ways, that's better for me, because then that person can be totally isolated from the hearing process and so there wouldn't be any issue if you're divulging confidential settlement information to that person, then he or she would just not be involved in the hearing process. So let me know, have a productive discussion amongst the four parties and your representatives. Decide whether you think mediation makes sense. Decide whether you want to hire. From my point of view, if you can hire an outside mediator, great. As I say, I've worked with some in the past who were very good. I think what's called knocking heads and getting things done, and put the fear of God into you about what's going to happen if you don't settle and stuff like that. So anyway, Mr. Kim, you can do that. And if you decide you do not want to do that for whatever reason, monetary or otherwise, let me know as soon as you can. And then I will investigate what we can do at the water board. This is all new ground for us, but I have full support of my board to get things done. And getting things done can include mediation and resolution. So I will go to the board if necessary to get authority for this. Everybody's very busy. Unfortunately, the December storms did not carry into January, so we're headed into another drought, which makes things really busy at the water board. But we will do what we can, as this is important. So I hope, does that more or less answer your question, Mr. Kim?
Yes, thank you so much.
All right, you're welcome. It's a good question and not a very good answer, but it's the best I can do. So please, the main thing is get on it right away. As in, you could have a conference call this afternoon to talk about this. And just don't wait. Let's keep going and do that. And frankly, it saves you all a lot of time and energy if you can settle before you have to do hearing prep. Okay, go ahead, Mr. Kim.
Yeah, understood. Yeah, so as Ms. O'Sullivan mentioned, we just got the settlement proposal, and we do need some time to preliminarily assess its terms and figure out how wide the chasm is, so to speak. So there will be some time involved in doing that, and I certainly have participated in mediations for several decades with private mediators, and you're right, there are many very good mediators, but there also is a value in having someone mediate with experience in the field, and so that's why I was very curious about your offer for having a mediator appointed from someone in your office who I presume would have significantly more experience on these issues than a retired judge who has specialties other than, these. So thank you very much.
Yeah, and just the caveat is the attorneys in my office and at the Office of Chief Counsel of the State Water Board have a lot of experience in water right matters and can, they can sort of say, here are possible scenarios, here are risks and so forth. They don't have as much experience doing mediation. So it's a trade-off. The one perfect person who has both, it's probably me, because I've done a few number of mediations and also hearings. Sorry, I don't want to be too egotistical here, but I can't be I will not be the mediator in a matter I'm going to be the hearing officer for. I'm just not going to do that. But anyway, I will, if you want to pursue it with the water board, I will follow up and see what I can find. No promises. There are a lot of very qualified attorneys in the Office of Chief Counsel. And I'll just see if they're all also more than fully busy right now with their current work, but I will see what I can do if you decide you want to do that. But I think, as you just said, Mr. Kim, first, see, I like how wide the chasm is. That's probably a good description. As we lawyers often say, define the issues and see whether, what the issues are, and then how wide the disagreements are on the different issues, and you can go forward. And I'm going to say this, well, maybe I shouldn't say. I'm going to say it anyway. Sometimes when I represented parties outside of the water board, some people said, Cal Fish and Wildlife and NOAA Fisheries, you'll never reach settlements with them. They're just totally unreasonable. And I just want to say, in my career, I have found the Cal Fish and Wildlife and NOAA representatives to be very professional. They're tough. They hold out for their clients' interests, as any good attorney does. But I have found them to be professional. I did in my days of representing parties enter into some fairly major settlement agreements with them. So don't be deterred. Your chasms may be wide, but you're all good professionals and can go forward. I've not ever negotiated with California Trout, but California Trout certainly has a reputation as a very responsible and reputable environmental organization. So I think they will fit in that category too. And of course, I know Ms. O'Sullivan and Mr. Kim, you and the city are highly professional and also will approach it that way. So kind of a pep talk. I feel like I'm the coach saying, go out in the game now and have a good game, but please do and see what you can work out. Anyway, probably enough said on that. Probably I babbled a little more than I should have, but go ahead. I'm going ahead. So with that, do people have any ideas of what's a reasonable time for, I'm going to ask for the first two dates first. Two dates would be deadline for submittal of written proposed testimony and exhibits, and then the date on which the hearing would start. And some of this obviously is going to depend on my calendar, but I just want to hear what the parties have to say about that. If they're, and this is brainstorming, I'm not going to hold you to this. I'm just, at the end of the day, we'll issue a hearing notice. But I do want to get some input. So I'll start with the city's attorneys, just because they're at the top of my list. So Ms. O'Sullivan or Mr. Kim, do you have any just sort of tentative ideas of what are reasonable dates for submission of exhibits and written proposed testimony and then hearing, with the thought that those two dates should probably be about 30 days apart? And if I hit you out of the blue with this, if you want to take a break and everybody to confer, would that be good to do? I'd rather spend a little time and internally discuss this. Ms. O'Sullivan, do you want a break or do you have dates now?
I don't have specific dates. I do have an understanding of a few conflicts I'm aware of, like times that wouldn't work for myself or Mr. Kim, but I have not sat down and looked at the calendar to pick a specific date to propose. Okay, that's not what, that's the other thing that can get to be a horrible mess is when we try to work out people's calendars. But at this point, I'm just looking for concepts. Do you think like 30 days to prepare and submit exhibits, or 60 days or 90 days? What sort of time frame
do you think is appropriate for the city to have time to prepare its written proposed testimony, assemble all its exhibits and number them and so forth, and submit them?
I think maybe a break might be helpful, but I don't want to, I know we're getting on an hour, so I don't want to presume everyone.
No, it's fine. I'd like to wrap this up by 10:30. I do have another hearing starting at 11, but what we can do is, and this is not just for the city, but also for the other parties, if they're people you can confer with. But I'm going to go ahead and just, we'll go on mute. Don't log off because you might have trouble logging back on, but you can just go on mute and turn off your camera, and let's just come back at 10 o'clock and see. And again, I'm at this point looking for kind of conceptual ideas, 30, 60, 90 days for a deadline for submitting exhibits, and then potentially 30 more days for starting the hearing. So let's temporarily sign off and be back at 10 o'clock. Thank you.
Thank you.
All right. We're, looks like almost everybody is back who was here before. So let's go ahead and get started. Sorry if I put you on the spot before, Ms. O'Sullivan, but after having at least a brief time to confer, do you have any proposals for kind of rough time ahead? And I do say one of the things I try to do is get the hearing notices out as far in advance as I can, just so it can help you all with your calendars. But you have any idea of what's a rough time frame for getting started with the process?
Well, Mr. Lilly, I think based on Mr. Kim and my scheduling with other trials and planned leave, that realistically, just looking at like how you had mapped out the hearing schedule in your September 2nd order and wanting to provide enough time for preparation now that the technical documents are available, and for the city and the remaining parties to have meaningful settlement discussions. The city would ideally for us would be starting, the deadline for a pre-hearing conference and starting the process sometime in late August. And that would be our preference, would be to push it out that direction.
Okay, so, and that would be for the deadline for submitting exhibits and then the hearing after that?
I was suggesting that the pre-hearing conference be in late August, and then I think those are like a couple of, I guess the deadline, and then the deadline for proposed testimony would be a few weeks after that. I forget how far apart you had spaced the pre-hearing conference and the deadline to submit exhibits, and then the following dates could track from there.
Okay. And just so we're clear, to some extent, I do see my September 2nd notice. Thank you for reminding me about that. And I do see I had a pre-hearing conference about a month before the exhibit filing deadline. And we probably should do that here. One of the main reasons for a pre-hearing conference is for me to say what I just said today about, basically, I really mean it when we say you have to have your written proposed testimony cover your testimony. But we should probably still have another pre-hearing conference. So, okay. So I would say, I'm hearing you say then the deadline for submittal of exhibits and written proposed testimony would be late September, and then a hearing would just say late October. Is that sort of what you're suggesting?
Thank you. Yes.
Okay. And again, we're just brainstorming. I'll say that's probably going to be too long for me, just to be candid. And, believe me, I know what it's like to be busy as an attorney. I did it for a long time.
Yes. And if I can just say, the other factor is I will be on family leave from starting at the June to August timeframe. So that's part of this as well.
Okay. Well, I certainly respect that. And I don't want to, I don't want to conflict with that. On the other hand, I think, as I said before, I've got 5 board members who've told me I need to revamp the water rights process at the State Water Board. And the biggest problem is we don't ever get anything done, to kind of put it in casual terms. But the first time I sat down with Joaquin Esquivel, that was pretty much what he said. Alan, the water rights system in California is broken. You need to fix it. And the way to fix it is to get prompt decisions out. And then I heard that from the other 4 board members when I met with them. So they're the people I report to. So anyway, that I'm grappling with your comments because I want to respect them. But on the other hand, I have some instructions that require things to be prompter. And this one originally was assigned to my office back in 2020. I think it was the very first matter that was ever assigned to my office. So we're getting up on 2 years since the assignment. We had to delay it for the city to work through, to refine its proposed project and to work through the CEQA. But I just don't know that I can delay it that much longer. And I know, Ms. O'Sullivan, you're now taking the lead. I also do know that you work for a large firm with many attorneys. So we'll have to see how that plays out. And I know Mr. Kim is experienced in water right matters because he's appearing in some other matters before my office. So anyway, well, I appreciate your comments. Let's go forward. Let me circle over next to Mr. Kim. Your hand is up. I just gave you a compliment. You don't argue with it. Go ahead. I'm kidding.
Yeah, so we do have some real logistical timing challenges between Ms. O'Sullivan and I. And the other conflict that I have is I have a month-long trial in June that may go into July. And so, Ms. Sullivan and I are the only attorneys who are on this case. And, even though we do have a firm of other lawyers, we are the only people that have been working on this case. So I understand, your directives and challenges, but I just wanted to give you a full picture of the scheduling issues that we face and why Ms. O'Sullivan gave the timing proposal that she had given.
Right. Okay. All right. Well, let me go around the room, the virtual room, so to speak. I'm going to start with Ms. Hall. Do you have any comments on proposed schedule here?
In the brief time that we just conferred, we basically just came up with a minimum that we would need time over the coming months, 60 to 90 days or so to line up our experts and prepare evidence for a hearing. But hearing about the city's schedule, we would certainly not oppose having even more time and following along their time frame to work around their conflicts.
Okay. Thank you.
Another
Go ahead.
question is, do we know at this time whether the hearing would be remote on Zoom or if it would be in person?
Good question. And the answer is, unless there is some change in the applicable statutes, I plan to do the hearing by Zoom. It's just better all around, I think. I get a much better record because everybody's face is on the recording, and we post exhibits and they're right on the recording too. I think it's a far better record than a court reporter can do. Sometimes parties order a court reporter, and they certainly may, to have that transcript as well. But I think the Zoom recording gives a better record. Back when we were in the office, it was just a real challenge to get hearing rooms. I don't know whether that's still a problem since nobody's there much anymore, but that's the other logistical thing. Plus, you're from all over the Western United States, so I think it's easier for you not to have to all come to Sacramento for a hearing. So anyway, the answer is yes, it'll be by Zoom unless there's some legal requirement that we can't. Now, there will be a site visit, which obviously we have to do in person, but the rest would be by Zoom. Okay.
Great. Definitely appreciate Zoom hearing, and we have one expert that would only be available via Zoom anyway. So I wanted to check before we committed to working with them.
Yeah. The biggest challenge with Zoom I found is if you have people on different time zones, particularly if they're on the other side of the world, that can be pretty brutal for people who have to testify in the middle of the night. Other than that, Zoom seems to work pretty well. And so far, there's no technical way to get around time zone changes. All right, so I'll start with you, Mr. Broomback. What does NOAA Fisheries have to? Excuse me, Mr. Broomback. Before I ask you, I do want to just say here, or ask Ms. O'Sullivan and Mr. Kim. This is a case where the city the city's existing facilities are authorized by the existing permits. Is that correct? So this would only be permitting required for proposed new wells. Is that right?
Yes, Mr. Lilly, that's correct. And as part of our project description, we're also requesting to shift the reach of diversion so that the new wells can go, it'll encompass the existing wells still, but that it will, the reach of diversion, the new wells we would like to place in a slightly different place on the river than our current reach is. So there's new wells and a shifting of the reach, but yes, we are currently operating under our existing permit. And this petition is about adding 2 new wells.
That's what I remembered. And the reason I ask is sometimes we have a case where there's an unauthorized diversion going on, either because it's an enforcement action or because there's something where somebody's seeking a permit for an existing diversion. And then there's perhaps more imminence than if the city is willing to wait until there's a board order before doing the actual construction, which seems to be the case here. So that's an important consideration. So sorry, Mr. Broomback, I asked, calling you and then interrupted. What are NOAA Fisheries' views on schedule here?
Well, I was only able to consult with myself. So I wasn't able to talk to Ms. Beal, so I'm kind of at a loss. I apologize for that.
Do you have any comments you'd like to make on behalf of yourself? I certainly understand that caveat.
I would say, just given the volume of material that we did receive in the addendum, somewhere along at least the 60 to 90 days would be very helpful to be able to give it its due review.
Okay. All right, Ms. Germanario, for Cal Fish and Wildlife, I know you did not, Cal Fish and Wildlife did not file a protest, but I suspect that, I'm not sure, but if Cal Fish and Wildlife wants to participate, I think they're going to be, I will allow them to participate within the scope of the protest issues that other parties have raised. So with that caveat, do you have any ideas on schedule?
Yeah, thanks, Mr. Lilly, for acknowledging that and allowing us to participate. I think we do intend to do that. I would say at this point, a caveat that we haven't had a chance to consult with our client, potential experts. In our view, there's still significant gaps in the technical analysis and issues related to the CEQA documentation. So that for that reason, I think we'd need at minimum 90 days to complete our analysis. But we would also likely support the city's requested timeline. To put a finer point on that, some of the things that we're dealing with is, we're going to probably have multiple experts in different fields, biology, hydrogeology, and to make sure that we get that, testimony and have the availability of the staff that are needed for that, and working around their workloads and schedules will be a little bit of a challenge. So yeah, I think in short, we would support the city's proposal.
Okay. Okay, I believe the other parties all either have signed, the representatives have signed settlement agreements with the city, or they're going to participate just as necessary. But does anybody else want to give any comments on the proposed schedule?
I guess one question just arose for me, Mr. Lilly, is whether the fisheries parties, CalTrout, CDFW, and NIMS would work together to do anything jointly in terms of evidence or briefing, or if it's anticipated that that would be done separately.
That's a very good question. Thank you for asking that. And the answer is, I strongly encourage those 3 parties to work together to make a joint presentation. I don't think I can legally require that. I think under your due process rights, you're allowed to present separate cases. But frankly, it's going to be a lot easier for me to process and probably for you all, the 3 parties, to present it if you do a unified presentation. So I certainly have no objections to the 3 parties doing a unified presentation with a panel of witnesses. And, if necessary, if there are time issues regarding how much time for witnesses to summarize their testimony, I'd certainly be willing to give you some accommodation for that if you're doing it as a panel rather than 3 separate presentations. So a long way of saying, yes, please, to the extent you can coordinate, that's just better. It's better for me. And frankly, I think it's better for the city as well to kind of have one unified presentation that it's evaluating and responding to rather than 3 overlapping, but maybe not 100% consistent presentations. So yes, and if we need to have another pre-hearing conference to discuss the logistics of exactly how that is done, we certainly can. But yes, I would very much support a unified presentation by those 3 parties.
Thank you. And I should add the caveat that I, of course, have not run this by the other parties or proposed it in any way. So I don't know anyone's position on whether they would want to go that route. But I just wanted to know whether that was anticipated as part of the process. So
yes. And they may have, I'll just say from experience, they may have limitations as government agencies and what they can do. But if you can, that certainly is, from my point of view, that's very valuable. So, okay, does anyone else want to say anything about schedule? You've all made it really hard for me, I will say that. On the other hand, I'd rather hear it now than after I issue a hearing notice and then potentially need to change that. I'm going to have to evaluate my calendar and figure out how to go forward with this. But I do have your input. Just to reiterate what I'm hearing from the city and at least some support from the other parties, at least from Cal Trout, is, well, I'll say the fishery agencies all maybe didn't ask for this, but they're not challenging it or opposing it. The city would like to have a pre-hearing conference, and I wrote down late August, the deadline for submitting written proposed testimony and other exhibits in late September, and then the hearing starting in late October. We'll just kind of in rough terms. So we'll have to see about that. And just to confirm, Ms. O'Sullivan, you're out from June, all of June through August?
It's I can't be 100% certain, but I anticipate being out, yes, starting around the first week of June, and then I should be back by the last week of August. Though certainly a pre-hearing conference, I think Mr. Kim could certainly handle that if I was still on leave.
He'd probably be able to do okay, but I'm sure he'd rather have you involved if he could.
Yes.
No,
Thank you.
I do want to respect that if I can, because I mean that's clearly personally very important to you. I just I know we've had to respect this with other people, and I want to respect it with you as well. The only problem I'm grappling with is if we start accommodating everybody's schedule, we may not do this hearing for years. So I will try to work that through. Anyway, thank you for letting me know as well. That's good news. All right, what I'm going to do is go through this with my staff and look at my calendar and figure out what the best thing to do is. And then the one thing I do want to do is give you all as much notice in advance as possible, basically so that then you can put dates on your calendars and hopefully we don't have to change things later. So I may issue an order with my proposed schedule before I issue the formal notice of hearing, just so you can sort of have the dates on your calendar, because the hearing notice does take us a little more time to prepare, and that's the only reason. And I'll just say, if we set this schedule this far in advance, then I really am going to mean it as far as not changing it. And I'll give you a little more time to settle than maybe I had contemplated, but you still will have deadlines. And I'm really, really, really not going to want to change the schedule if you come to me in August and say, we're really close. Just give us another 30 days and we'll be able to wrap this up. So I'll just say that now. That's my point. And again, this is mainly, I have 5 bosses telling me to do this, and they're all giving me a very clear message. So, okay, I've probably rambled way too much, but thank you all for bearing with me. Thank you very much for your input. Is there anything else we need to cover today?
If I may, Mr.
Go
Lilly,
ahead.
I just
Go
wanted
ahead.
to flag that I sent an email to the AHO's email address requesting that the service list be updated for the city. So all the parties were copied. So hopefully everyone's aware of that, but just wanted to flag that since we have new staff with Mr. Acosta and wanting to update that service list for the city.
Yeah, and I think your email said you weren't even on the email service list, and that was
That's right.
pretty bad oversight on our part.
Well, on mine as well. I should have formally asked sooner.
Well, I'm sure Mr. Kim is more than happy to forward things to you, but we should make sure you're on. So speaking of setting things up, my office is in the process of having a more formalized process for email, basically, or whatever you call the things, the Outlook contacts list, so we can have a group that we can just update readily when parties come into email. And then also for our service list, it's just something else. I mean, it sounds simple, but it's just one more administrative thing we're working on. So we will try. And if you or anybody else sees that we are missing somebody or have somebody on who should not be on, please let us know, and we will do the best we can to continue to update that. I mean, that's the deal is everybody accepts email service, and our responsibility in my office is to make sure we send the emails to everybody. So if we're not doing that right, please let us know and we will clean that up. So thank you. Anything else for today, or shall we wrap it up? All right. Well, thank you all very much for tolerating my ramblings and mainly for providing your input on schedule. So let's see what we can do. And I will get, probably in the next few weeks, we'll get out at least a preliminary order with our proposed schedule, and we'll go from there. And it's, as I say, if anything else comes up in the meantime, you're all very good at this. Feel free to send me send an email to the AHO email address, and you can address it to me, and just include everybody on the service list on that. And that way there are no issues with ex parte contacts, and we'll remain in communication. But one way or another, we'll get the hearing scheduled and move forward. So anything else for today? No more hands up? All right. Thank you all. Have a very good day, and thank you for your participation this morning. Bye.
Thank you.
Thank you.